knows that the duration was completely unrealistic, forgets all of that. He gets like a Jedi mind trick, and in his mind, all he remembers is he tendered the perfect tender. Everything was 100%, and this contractor is messing everything up. So the employer goes, and he comes and he says to him, how's it going? He says, well, we've got a bit of a problem with the contractor. So what's the problem with the contractor? Well, the contractor wants more money, he wants more time. And he says to the engineer, is that fair? And the guy, oh, no, that's not fair. And this is where the horror comes in. Because then they go to our colleagues next door, to the lawyers. And they say to the lawyers, do you think that's fair? And the lawyers say, oh, no, that's definitely not fair. We agree with your engineer. And then you end up, and this is how probably 80% of all disputes in the construction industry stem from an understanding of that little story.
Thank you. Segue into me then. So obviously Terry's given the fun facts. I'm going to be a little bit drier because my central proposition is that FIDIC's attempt to make the engineer both the employer's contractual representative and an independent certifier is structurally incoherent. I'll tell you why. The contract drafting itself reveals this contradiction. I've got notes because lawyers always have notes, so I'll have some too. So we're not saying that engineers are unethical or anything like that. What we're saying is that the institutional design of the contract creates unavoidable conflicts of loyalty and perception. To illustrate this, I'm going to show you two fundamental clauses in FIDIC, if this works. Can I reclaim my time, please? No. It's not working. Oh, okay. So clause 3.2 expressly says the engineer should be deemed to act for the employer. It's still not working. There you go. And this expressly establishes agency as far as the engineer is concerned. And then compare that with 3.7, which is only a couple of pages later and says the engineer is not deemed to act for the employer in certain circumstances. Now, I mean, if you're standing there looking at this plainly, it's ludicrous, but FIDIC is there trying to carve out an artificial neutrality bubble because it recognizes that there's an underlying conflict. The problem is you can't switch neutrality on and off like a light switch. An individual cannot realistically move between an advocate and an adjudicator depending on which clause they're operating under. I come back to my second point, which is that the engineer's economic dependence on the employer gives rise to structural bias. So the engineer is appointed by the employer, he's paid by the employer, he can be removed or replaced, and he's commercially reliant on repeat business from the employer. Yet, he's expected to certify payments fairly, he's expected to determine extensions of the time and decide claims neutrally. Natural justice is not merely about impartiality, it's about the appearance of impartiality. And even if the engineer acts honestly, the contract could reasonably perceive some existence of institutional pressure, commercial dependency, and incentives toward bias. So that perception alone undermines confidence in certifications being carried out by the engineer. I'm sure my friends with the opposing motion will agree a simple statement: justice must not only be done, it must be seen to be done. FIDIC simply asks us to believe that the referee in a high-stakes game can wear one team's badge for part of the match and then suddenly become neutral when a contentious decision rises. Like, if any, oh, I'll move, sir. If anyone can see what the referee is wearing, I'm sure you'll understand my point. It's a simple point to make. How am I doing for time? I've got a few minutes. Okay, thank you. So let me just do a couple more. So in FIDIC, the engineer controls interim payment certificates, variations, EOT determinations, performance assessments, and taking over the project. So these decisions directly affect employer cash flow, liquidated damages exposure, and project financing arrangements. The engineer is simultaneously managing the employer's commercial risk while purporting to adjudicate disputes arising from the same risk and doing so independently. Another structural problem with FIDIC is that DABs, modern FIDICs promote DABs. We rely on DABs. Why? Because the engineer's determinations alone are insufficient. So at that point, I'm going to hand back to Terry because he's got a couple of points that he's dying to make.
Yeah, just to say that a very graphic illustration of the situation that ends up in a great many projects, and one of the fundamental causes of disputes in construction is that you end up creating us versus them. And this is just a very clear indication of what that is when you have the two sides entrench themselves and they each associate, they have similar corporate identities, similar corporate cultures, and you find that the employer and his agents have a very similar corporate culture, a similar corporate identity to the contractor. And it's very easy because they're involved in the project before the project even commences. They're already on that team. That by the time the project starts, you've already created a fundamental us. And then when you go out and tender, you're bringing them in. And then throughout the project, you have us versus them.
Great, thank you very much, and right on time. A round of applause. So there you've heard it, you've heard the in favour, to the for. Now we're going to move over to the legal team, who's now going to go and present to you within their 10-minute slot the against.
Thank you very much, Mr. Chairman. So in a moment, I'm going to talk about FIDIC, but before I do, it's great that we've got this image on the screen, because I'm also going to be talking about how the employer abuses its position and puts undue pressure on the engineer. Now, when I look at that photograph, I'm convinced that somebody used AI and put an all-black top on the referee. And frankly, that is a disgraceful piece of advocacy on the part of the engineers on the other side. Okay, let's just start. So this is a discussion not entirely about FIDIC, because the question is whether in principle the dual role of the engineer is feasible. But let's talk a little bit about FIDIC. What is the FIDIC system? Is it clear? Can it be improved? And does it work? Well, we know that, or most of you I'm sure know, that FIDIC's first contract came out in 1957. That was the very first contract, which was essentially based on the ICE form in the UK. And from before 1957 in the UK and earlier, the concept of having an impartial engineer was quite well known. And so the FIDIC form in 1957, in 1969, the second edition, in 1977, the third edition, all implied that the engineer would be impartial.